thank you for your hard work on this. And we've talked about this on the phone. If you could talk to us and talk basically the general public and the committee about what seems to be a new issue coming up out there, the app stacking issue.
Yes.
And what's going on there.
Yes, thank you, Senator. And yes, we did speak on the phone about this. So this has come up in sort of two different contexts, or we've been made aware of it in two separate contexts. One relates to businesses, so like a landlord who has said, look, we are going to have a dispensary here, or we're willing to have a dispensary here, and they enter into a contingent lease with multiple applicants at that location. That's perfectly fine. It's provided for in our regulations that individuals and businesses seeking to do business in this area can apply using a contingent lease. Of course, if somebody in that group is issued a license after the license lottery, then that individual or business will be issued a license, and that contingency will occur, and thus they will have a lease for the term of the license. And everyone else will, of course, not, and will have a dispensary or whatever business located there. The other context that this has come up in is with respect to, I guess, an inference or some rumor that individuals or businesses might try to influence the lottery process by trying to get around some of the provisions that we've provided in our regulations that limits the amount of applications a business or an individual can actually submit to us. So our regulations strictly provide that if you're applying for a cultivator, you can apply for a cultivator application in one of the three tiers that we're allowing. So you get one opportunity. You can also apply for a dispensary in each of the 11 licensing regions and no more. Now, the question has come up, well, what about these large out-of-state corporations creating multiple subsidiaries and applying? First of all, that's strictly prohibited. Also, we would know about it. And just to be clear, this has not come up. We have received 82 applications thus far, and not a single instance has this actually come up in practice. So want to make that very clear. So in that context, if a business, let's say that they're LLC A, which is a subsidiary of this larger corporation, they apply for a dispensary license in all 11 regions. That's perfectly fine. Let's say LLC B, which is also a subsidiary of this larger corporation, goes ahead and tries to file an application in all 11 regions. That would be prohibited, and those applications would be found deficient, and they would not be permitted to be in the lottery. And how do we determine whether there's a subsidiary? Well, we require in these regulations them to provide us their ownership, their corporate structure, and they have to explicitly disclose whether they have a parent of any kind. So through these mechanisms, we're able to determine whether there is a parent company, and because we define the parent as the applicant, in that case, the parent company can't, in a sense, load the lottery with multiple applications. They're restricted just like anybody else would be to those 11 dispensary applications if they so chose, or one of the three cultivation tiers. I hope that answers the question.
Yes, it does, and I appreciate that. The main reason I asked the question is to get it out in the public domain. But for further clarification, so if you got a gentleman, a Kentucky citizen, let's say John Smith.
Yes.
John Smith opens 10 LLCs, makes 10 applications for the same entity, whether it's a cultivator or dispensary or whatever, under existing reg, that would be disallowed.
So it would, first of all, it would depend on the ownership. structure in the LLC. So, for example, they have to. So, an individual would have to report if they have more than 10% ownership in any one of these. So, if we're made aware of that, of course, we can go ahead and stop that. Now,
So the bright line is 10% ownership.
that's exactly right.
Gotcha. I didn't mean to interrupt. Go ahead.
No. That's in sum what the regulation provides.
And so the intent clearly of SB 47 and 829 was never to allow one entity to have a monopoly on locations and whether it be cultivation or dispensaries, and quite the opposite, for there to be a bright line of distinction between the two, so there could be no overlap, correct?
That's correct, Senator. And we've designed these regs to follow not just the letter but the intent of that law, to ensure that everybody has an equal and fair opportunity to be part of this new industry in Kentucky.
Thank you very much.
Thank you.
Thank you for being here, and I appreciate you for continuously answering questions. I feel like as of the past month or so, this is probably, I get more questions about this issue than anything else, and it's been, I know it's a tedious process trying to work best practices, because it seems like every state that we've looked at has messed it up pretty royally, and so I appreciate that, how hard it is to get this out. I have been trying to encourage making sure local people, Kentuckians, invest in this resource so that we keep money back home. And that was when I got hit. And you answered a lot of questions. They were worried about kind of getting pushed out. In the event, though, that I have local investors and they want to invest in 8, 9, 2% of 15 different applications, is there any restriction on them doing that?
So no. So the threshold is 10%, and the reason why it is 10% is because once you get beyond that, it becomes very, very difficult to determine actual ownership, right? So, for example, if a large corporation, right, was to be required to provide all of their ownership, and they're publicly traded, we're talking about potentially them putting millions of individuals or shareholders in their application. Yeah. And of course, we don't want to go there.
Yeah, no, thank you. And I just wanted to make sure that was clear, because I know that is one that I hit a lot. And then in the event that someone owns 20% of 3 different applications in there, then that because they've crossed that threshold, after the first application hits, the second one that they have more than 10% would be thrown out.
Yeah, so that's required in their disclosure to provide that to us.
Thank you.